We can go up and running.
Maybe not.
Well, I was awake at about 3.
Were you?
Yeah. So,
You didn't get up, did you?
oh, thank you very much. Well, good morning, everyone. We're going to get started. Everybody's excited and bright-eyed and bushy-tailed and ready to go. I love it. I love it. And congratulations on getting here. You know, that's a pretty good little reservoir filler out there, Mr. McAgna. That's a good thing, right? Yeah.
Maybe
Judy,
thank you.
Yeah, Judy, let's call this to order and please take the roll for us.
Senator Case?
Present.
Senator Cooper?
Here.
Senator Furphy?
Excused.
Excuse. Senator Schuler?
Here.
And Chairman Landon.
I'm here. Well, committee, we are going to take up and continue with Senate File 34, trespass by small unmanned aircraft. That's a continuance from last Friday. I hope everybody can remember back that far. We've done a lot of work since then, but I'm looking out across to see if Mr. Kennedy is in here. He kind of left off, and I'll give him an opportunity if he gets in this morning. We want to continue testimony on the bill. So I would invite anyone who has not had the opportunity to please come forward and testify on Senate File 34, trespass by small unmanned aircraft. This is a bill sponsored by the Interim Judiciary Committee. Good morning.
Good morning. Thank you, Mr. Chairman and members of the committee. My name is Sabrina King. I am the lobbyist for the Wyoming chapter of Backcountry Hunters and Anglers. I sent you all some just background information over the weekend, but I want to just reiterate that our organization doesn't have a position on this bill, provided that some of the language remains the same. What we do have an interest in is general airspace law, in no small part because there are some disputes about what trespass through airspace means. And I think our interest is in, with this bill, just making sure that we aren't sort of backdooring a change to that standard. So what the Judiciary Committee, the joint interim discussed was basically taking what is in civil law and putting it into our criminal code. So I'll just read for reference so you can kind of track the language. What has come out of the court cases that I sent you, it is now in the second restatement of torts, and it reads, flight by aircraft in the airspace above the land of another is trespass if, but only if, A, it enters into the immediate reaches of the airspace next to the land, and B, it interferes substantially with the other's use and enjoyment of his land. So it's literally word for word what's in the bill right now. So Judiciary decided if we are going to address drones as trespass, we will just take what is in civil law, we will put it into our criminal code, and that will be how we will address the issue. From our standpoint, as I said, if that language stays the same, you know, who it applies to and how else that works, we have no position. Just a couple of other things that I would mention. There were some questions about, well, how would you know, if it's a significant interference, what means use and enjoyment? Because we're putting this in our criminal code under criminal trespass, that's to a jury to decide. So the jury will figure that out. There is some, leeway in terms of law enforcement and who they actually charge with this, but at the end of the day, it will be a jury. It is also, I think, important to remember and just to consider as we're going through this bill that because of where we have put this, the definition of landowner applies to anyone in the state of Wyoming who owns some land. So this applies as much to Central Cheyenne as it applies to a farmer out in the field. So in terms of lowering that standard and making it potentially easier to charge, you are entering into a space where, in terms of what law enforcement in cities is going to have to be dealing with, might be difficult. So the standard as it's set out on the bill, from our perspective, tracks with historically what we've had. So we are fine with that. So we would urge the committee not to change that language. And outside of that, we have no position on the bill.
Thank you very much, Ms. King, for being here this morning. Questions for backcountry folks? Senator Case.
Just, Mr. Chairman, I think I'm kind of in agreements. I mean, I've been trying to research this too, and a lot of states, I looked at other states' laws, and there is a lot in there that relates to like more tort actions, but still in the criminal code. So some of those use a privacy standard, like where you have an expectation of privacy, like backyard picnic table or maybe your hot tub, that is stricter standard than that. But I kind of like the way you described it.
You know, Ms. King, you touched on a couple of things. Thank you for your testimony. That's helpful and gets us off to a good start this morning. It's not that you could not be charged with trespass now, correct? In other words, trespass is trespass. If I had a good attorney, like the former chairman of our committee, for example, and I could go to court, by golly, we'd still have a chance to prove that it was trespass, even without us putting this in statute. Is that correct?
Mr. Chairman and members of the committee, this is sort of one of the very interesting questions that we haven't really answered, which is why there's a court case going through, right? It is a civil case, but it is directly looking at this question as to what is airspace trespass? The court will sort of make its decisions in due time. But what I would also point the committee to in terms of thinking of trespass as trespass, if you look at criminal trespass as it's written in Section 6 right now, the burden is on the landowner to give some sort of signal as to the fact that you are trespassing. So whether through a sign or a fence, or if they tell you that you are trespassing, you have to leave. When it comes to airspace trespass, it's nearly impossible to do that. It's almost impossible if you are, say, flying a drone 50 feet, across, even if you're on your land, to know that you haven't just clipped your neighbor's land. So I think it is a difficult proposal, I think, to say that the analog is, if you go over someone's airspace, you are directly trespassing in the way that our criminal trespass laws are written, because criminal trespass requires notice. And you almost can't unless every landowner in the state of Wyoming is going to put up little laser lights, all along their borders. So it is a different proposition. And I think that's why airspace trespass gets very complicated very quickly, because it's easy to post a sign that says, do not trespass on my land. A lot harder to figure out how you make that clear in the airspace.
I hadn't thought about it that way. And, maybe you put a helium balloon up there and say you're not allowed right here. But then you've got to fill it with helium all the time.
Yeah.
I'm kidding.
Yeah.
I think, that's very well put again. Thank you for that. It seems to me that it's appropriate that we're taking this up. Yeah. Senator Schuler.
Thank you, Mr. Chairman. Just a quick question on the language as is. You say you feel good about, your group does. We had quite a bit of conversation about substantially, whether we should take that out or leave it in. What are your thoughts on that?
Mr. Chairman, Senator Schuler, we think that, one of the reasons that we're testifying is we think that word substantially needs to change. That is the current standard. If we want to have a different standard, then I think we need to talk about the underlying law and actually have a broader conversation about airspace trespass. The committee over the course of the summer didn't really do that. It pretty much has been this language the whole time. And I think given that that is the language, that is the torts language, that is what has been used by the courts, that's the current standard. And again, when it comes to figuring out what that means, that is for a jury to decide. So I think they can figure out, hopefully, whether there's substantial interference. And again, because we are also talking about all of the land in the state of Wyoming, if you are in the city of Cheyenne, if we're getting into, say, a scenario where every, drone that happens to clip the edge of your land, people are saying, well, that interferes. The substantial kind of gets you over a little bit of that hurdle and ensures that it is only really when your enjoyment of the land is being impeded.
Any other questions, committee? Thank you, Ms. King. Really appreciate it. Thank you very much. Further testimony on Senate File 34. Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. I am a flight instructor. You have an potential issue with FAA rules for controlled airspace versus uncontrolled. Around Cheyenne here up in Casper, they technically control the airspace all the way to the ground. Now, there's rules about whether you can or can't use drones in that airspace also, but LSO ought to take a look at that and make sure you don't have a conflict. I had something like this happen to me out on my property out near Bondurant, uncontrolled airspace.
You do live in God's country in Sublette County, by the way, so
Yes, sir.
go ahead, yeah.
Yes, sir, Mr. Chairman. But I had a neighbor do something like that, flew one of these within about 50 feet of my dining room windows. I reported it to the sheriff, didn't ask for anything to be done, but I never saw that happen again. So I think something like this is very appropriate. And the only issue I would offer is just that thing about potential conflicts with the federal aviation regulations. Subject to your questions. Thank you.
Mr. Winnie, thank you. And I did some checking. Appreciate you weighing in on that front because it's still in development, but technically it was taken up during the interim a little bit, and the FAA has ceded that authority below 500 feet is the short version of that, but it's still in development. I mean, this is let's face it, this is a brand new area of concern for our laws. And so any questions for Mr. Winnie? Go ahead, Senator Cooper.
Thank you, Mr. Chairman. Mr. Winnie, do you know, do the FFA regulations supersede state regulations to the federal?
Yes, sir, they do. They when they set up the FAA years ago, I guess it was back in the 20s now, they control aviation throughout the nation.
Thank you, sir. I believe I said FFA, but that stands for Fathers Feeding Animals. That's a different deal. So.
I understood that one, yes, sir.
And that you were out in the backyard, we knew where you were going, Senator Case.
Mr. Winnie, can you remind me what the FFA says about how high an aircraft can be above a structure?
Above a structure?
Yes.
I believe the rules are simply that they not strike the structure typically.
Mr. Chairman?
Go ahead, Senator.
There's a rule about occupied, or it's at least 500 feet.
Well, there's rules above the surface, and they vary whether you're there are people in the area or it's bare land. Typically 500 feet or perhaps 1,500 feet if there's
Over a city.
Over people, assemblages and things like that.
Yeah. So, Mr. Chairman, I think it's 500 feet above. If you're flying a private plane,
I believe you're right.
you can't go closer than 500 feet. But that is related to a structure, and you can drop down lower elsewhere, and frequently happens. The other thing is, over a community, there's a flight pattern for the airport, and some are as low as 800 feet, but most of them are 1,000 feet. And so, there's just some things to think about. And he is right, around Cheyenne, there's this thing that's like an inverted wedding cake, where the FAA gets closer, exerts more jurisdiction because you get closer to the runway. They can do it all the way down. There was a pretty significant case in Cheyenne a few years ago where somebody had to cut down their trees. I don't know if you guys remember, but I'm sure that Mr. Kasich does, because I think he was mayor at the time. And it related to the city authority, but they were implementing FAA things. Sorry. Thank you, Mr. Winnie. It's good to have your knowledge.
Now, Mr. Chairman, that thing you mentioned about 500 feet, my point would be right around an airport like here in Cheyenne, it can go all the way to the ground.
We had an issue, Senator and Mr. Winnie, we had an issue at the Casper Airport as well, where somebody had to remove something that was in a flight path. Really wasn't that much in the way, but they didn't want it in the way, and they have the right to do that. So.
Yes, sir. That gets the structures penetrating that airspace.
Correct. Well, Mr. Winnie, thank you. Appreciate your testimony this morning. Further testimony. Mr. Taylor, good morning.
Good morning, Mr. Chairman, members of the committee. Sean Taylor on behalf of Wyoming's Rural Electric Cooperatives. My apologies for not being here on Friday to testify, but I believe Mr. Case and maybe others probably raised the same concerns we have in terms of our co-op using drones to fly our lines and patrol our lines and substations. And I believe the committee has an amendment that was drafted that I had a chance to look at this morning that we would agree with. So I don't need to restate anything, just to let you all know that we had some concerns because some of our co-ops do use drones to patrol our stuff, and we'd like to be able to continue to do so. So I'd be happy to answer any questions.
Appreciate that, Mr. Taylor. There's a lot of co-ops out across. So any questions for the WRA? So Mr. Taylor, just, we talked a little bit in the hall the other day. It feels like to me that it would have to be pretty onerous, what your guys and gals are up to out there for a landowner they're pretty much going to know, and you do pretty advanced notice kinds of things, right? I mean, it's not like you're going to go out there and do this. And if you're out there and they know the power's off, probably okay, aren't we? I mean, it seems like common sense is going to prevail, but I don't know.
Yeah, Mr. Chairman, you're right. And, we do have plenty of advance notice, and we have, relatively good working relationships with our landowners. Excuse me?
They're members of your.
Our members, yes.
Yeah, we get that little bonus check, right?
There you go. That's
after,
right.
In December.
You're welcome.
Yeah, we like
Do
that.
But I did, in talking to and looking at the amendment, I think our folks would be comfortable having some level of certainty rather than just kind of trusting common sense that everybody understands why we're out there. I think this amendment kind of covers us and gives us that assurity that we'd be covered.
Okay, appreciate that. Senator Cooper.
Thank you, Mr. Chairman. Mr. Taylor, how do you handle it when you go in with a pickup truck? You call the landowner and let them know you're going to be there, and you have normally you would have a right of way of some sort. Is that correct?
Mr. Chairman, Senator Cooper, for the most part, yeah, that's correct. And if we go out in a truck, we try and give as much notice as we can. If it's to deal with an outage, sometimes we don't have the ability or the time to do so, but we try and give as much advance notice as we can, whether it's with a drone or, if we're taking a crew out there. And for the most part, we do have the easements that we follow. So again, that's kind of another layer of protection, but I feel that this amendment kind of gives us that another set of certainty.
Feels like your lineman, Mr. Taylor, would know about those easements and have a pretty good idea of how to get to a line break. They're not going to cut right across the winter oats or anything, right?
Correct, Mr. Chairman.
Yeah. Thank you for
Thanks.
being here, Sean. Appreciate it. Further testimony on Senate File 34? There's some very polite people out there. Yeah, I know. I know. Good to have everybody here. Good discussion. Go
Thank
ahead.
you for the opportunity here to testify. My name is Jordan Evans. I live here in Cheyenne, Wyoming, and for my work, I am the coordinator of the Cheyenne and Laramie County GIS Cooperative, which we do coordinating of mapping and GIS activities between the city and county government, as well as any other local governments that happen to do GIS within our Laramie County. And part of what we do is we have two cooperatively owned UAS that we use for a variety of mapping and survey purposes, as well as other things that our members come up for it to use for inspections, things of that nature. And I just wanted to talk a little bit about how we use drones and how this might affect us here in Cheyenne specifically, because almost all of our operations are within that controlled airspace, and we have a 2-year period certificate of authorization that we renew every 2 years with the FAA. And if I may address Senator Case's point directly about the 500 feet above, drones under Part 107 of CFR, which is the primary federal guidance surrounding how to operate drones for commercial purposes, we are not allowed to operate above 400 feet AGL in uncontrolled airspace, or often in our waiver allows us to operate under all normal Part 107 rules within the controlled airspace. So meaning we actually are not allowed to fly above 400 feet AGL within the city of Cheyenne. And I believe that helicopters here from the Air Guard operate under similar rules. They have broad authority to operate however they like between 0 and 500 feet. And I've lived here my whole life, and trust me, they sometimes impede upon the enjoyment of our of our property. But I would like to say that many of our operations do cross, say, a subdivision that has just been built in, and we're trying to map it so that way we can put it into the aerial photos that we serve out through our mapping sites for folks. We do fly over private property at 350 feet above the ground, and so oftentimes I think people don't even know that we're there and operating. Inspections in order to get good views of some of the infrastructure that we're inspecting. Sometimes we fly over houses and things of that nature, all within compliance with Part 107 and the regulations that are there within. And then there's also the matter of our fire districts. We have, I believe, 3 rural fire districts here who operate under what's called a COA, Certificate of Authorization, and they've applied through the FAA to be recognized as public aircraft. And they have broad authority to do much of what they need to do for public safety purposes, responding to wrecks. Actually, my colleague Manny Musquiz, who's the Assistant Chief of the Laramie County Fire Authority, was going to join me today, but he texted me to say that he's helping someone on a wreck, and so he's not able to make it. But he is
imagine.
he's the main instigator of their drone program, and they have three drones that they use to respond to accidents, to look at fires with infrared, for search and rescue operations, and these are all things that are not accepted under the bill currently. And I've noticed that the bill does quote 14 CFR 1.1 in the general definition of what a UAS is. That is reaffirmed in Part 107, as well as there are definitions of how you become a certified remote pilot, and all of the hoops that you have to jump through to do that under Part 107. And then, and I'm not familiar with what governs the public aircraft portion of it, but there is also under federal law, all of the definitions for how a governmental entity or a public safety entity operates as a public aircraft. And I would encourage maybe exceptions for commercial pilots that are registered under Part 107 and flying as Part 107. Just because I am certified does not mean that all the flights that I do, if I have a personal drone, doesn't automatically mean that I'm flying under Part 107. It has to be for a commercial or business purpose. And I have to notify the tower whenever I fly within the city of Cheyenne. That's not the case in a Class G airspace in a rural area. But also public safety aircraft, these are defined in federal law, how people gain the certification and are able to operate. And I think that maybe putting exceptions into the law for those types of flights and operations might be worthwhile, because certainly if we had to just stick to public right of way or over property, it would impede a lot of what we do from a surveying and mapping standpoint, and certainly from a public safety standpoint. Not saying that it's a threat to public safety, but it is a threat to how they operate their drones.
Very helpful, Mr. Evans. Thank you for being here. Any questions? Senator Cooper.
Thank you, Mr. Chairman. Sir, when the surveyor's on the ground, clear back to the days of a chain and a transit, when they go on private land, do they ask permission?
They do.
Thank you.
So further questions? So I've got one, Mr. Evans. It feels like if there was a call made saying we've got a real problem with a drone, and we're pretty sure that he's only 75 feet above our property and they've been buzzing around all morning. It might be one of your pilots, for example.
Mm-hmm.
Don't you think that you would, that if the sheriff's department or somebody called you, the city would back you up, you'd have a legitimate purpose for doing what you're doing? And
Absolutely.
At that point, I'm hoping that common sense would prevail and the deputy sheriff would go on about his business.
Certainly, and I think that is possible. And I will say, in the 5 years that we've been operating UAS in Cheyenne, we've never once had a call or a complaint or a threat or someone. Mostly it's people curious that come up to us, say, hey, what are you doing? When we explain what's happening, truthfully, we've never once had a complaint about our operations.
Yeah. It doesn't feel like this bill would change what you just described. Is that your opinion? I mean,
Yes, I think that we would continue to operate in the way that we do already, which is non-obtrusively and for broad purposes. It's more in theory, the idea that, also with the way that airspace is controlled, if we're operating at 350 feet and we cross a private property to do a survey, is not a guard helicopter also trespassing in that situation? And we definitely, as part of being Part 107, we are informed by the FAA that we are part of the national airspace and that we are to consider ourselves an aircraft as part of the national airspace and to respect that and follow all the laws applicable therein. So we view ourselves as just another aircraft. And I understand the need to limit, I understand the privacy concerns. My neighbor landed his toy drone on my roof just over Christmas, and it wasn't a problem. We got a ladder out and we got it down. But I understand that those are issues that do deserve attention from the state legislature. But I do think that if you've gone through the process to become a public aircraft or Part 107 certified operator, then it should be acknowledged that you're operating in the national airspace just like any other aircraft, and the FAA views it that way.
thank you for that. Appreciate it, Mr. Evans.
Mr. Chairman.
Okay, Senator Case.
Thank you, Mr. Evans. Thank you very much. That was really great. If a private citizen has a concern about your operations and maybe argues that you're not in compliance with Part 107, can they complain to the FAA?
They absolutely can, yes.
So, yeah, Mr. Chairman, I think Mr. Evans has helped us a lot because now it's starting to, you got 500 feet above, for sure it's going to be the FAA. Drones operating under this public aircraft, which are lower, typically below 400 feet. They are regulated by the FAA and they have rules that they have to follow. That's, that their activities are going to be, their impact on your land is going to be more incidental, if you let me use that word, part of the job they're doing. Whereas when you get lower and you get amateur operators, their decisions are more deliberate, if you will, more, could be more malicious, could be more deliberate. I'm going to go check out Joe's pool. We'll see, there is, this exception would be a good exception. We actually had language. I think we should put it in.
Senator, I'm leaning the same way. I think you described that well. I think some of our amateur flyers are why we're getting lots of anecdotal emails, Mr. Evans. That's, people sneaking up underneath the porch roof, checking people out and all this stuff. I think that's really what led to and prompted this legislation in the first place. But if we choose to move some exception language in committee, it feels like this would be perhaps paragraph B or, subparagraph, whatever. If we choose, the other one that will be in front of us as we work the bill. So we'll sure take that under consideration, Mr. Evans, and if you can stick around, we may have a question for you later.
It sounds great. Thank you very much.
Thank you. Okay, further testimony on Senate File 34. Good morning.
Good morning, Mr. Chairman, members of the committee. Mary Ann Shaner on behalf of State Farm Insurance this morning. I understand that there may have been testimony at the prior meeting regarding use of drones by insurance companies. State Farm was the first company to be authorized by the Federal Aviation Administration to use drones. Currently, State Farm uses drones in two ways. First, for roof claim investigations, and second, for catastrophe responses. There's currently no specific language in their policies to address drones. So in the first instance, when they're looking at roof claims, they do get consent by the landowner in order to do that. In the second, what happens in Wyoming, you could see it being a wildfire, for example, with a disaster. And what they'll do is that they'll bring in large drones and be able to get a picture of what has happened with that catastrophe. In that situation, it's very difficult. You wouldn't be able to get permission of every single landowner to be able to use a drone in that circumstance. As such, we are supportive of an amendment, which I believe that you all have. If not, I do have paper copies of that here. And what that amendment would do is to clarify that State Farm and other companies could continue to use drones for commercial purposes. What the amendment reads is on page 2, line 8, insert, this section does not apply to a business entity doing business lawfully in the state using small unmanned aircraft for legitimate business purposes and operating the small unmanned aircraft in a manner consistent with applicable FAA rules, licenses, or exemptions. Mr. Chairman, with that, I stand for any questions.
Ms. Shaner, thank you. Senator Schuler.
Thank you, Mr. Chairman. Looking at the proposed amendment, I'm just wondering if it's in the right place. It says that page 2, line 8, I know we haven't talked about specifics yet without having moved the bill, but I'm wondering if that should be at the beginning of the section rather than line 8.
Excuse me, Mr. Chairman, Senator Schuler, yes, that is correct.
Okay.
I think that the intent of the amendment is to have it be a new subsection B, and so you are correct. I think that it should be line 6. Thank you.
Senator.
Thank you.
Yeah. So,
I'm gonna wait.
any other questions for State Farm? Mary Ann Shaner. Thank you for being here. Ms.
Thank
Shaner.
you.
Thank you. Further testimony on Senate File 34. Are we sure that's it? Really? Okay. Is there anyone online this
Yes,
morning?
we
Judy,
have,
let's go to.
Scott Richard, who would like to join.
Okay. You'd like to allow them in? We'll take testimony from our streaming. Okay, good morning. Hopefully you can hear us. Do you have your microphone on? We can certainly see you. So,
Yes, sir, Mr. Chairman.
okay.
My name is Scott Richard, and I'm the president of Wyoming Realtors. And we can appreciate why this bill was introduced, but we also have concerns with unintended consequences it'll have on professionals who operate them for commercial purposes. As I heard earlier, the FAA already requires anyone who wants to fly them commercially to obtain a Part 107 license. This license demonstrates that a remote pilot understands the regulations required to fly them safely. An example of this would be my own company. I employ a full-time marketing specialist who has a Part 107 license, and we use them to market our clients' properties for sale. We've even been hired by the Discovery Channel to film. And with that, my concern is what happens if my pilot accidentally flies over the corner of a neighbor's property, or as mentioned earlier, was getting an establishing shot of a community or a neighborhood. The majority of the complaints I've heard from the public in regards to this, because I've been flying for nearly 10 years, has all been usually a hobbyist that doesn't apply by the same set of rules that we do when it comes to having that license and flying safely. It's usually somebody that thinks it's going to be fun to fly. So I won't take up too much time. A lot of things have already been recapped earlier today, but my suggestion to the committee would be to modify the bill to say it was, trespassing if it was less than 100 feet without written permission, or better yet, to exclude somebody that has a commercial operation or business entity that flies under FAA regulations and rules. So with that, Mr. Chairman, I'll stand for any questions.
Mr. Richard, thank you. Appreciate you being here this morning. And the proposed amendment that was just read, I know you're listening to that on the fly, but it does reference FAA certification, I believe. Do you feel like that captures what you're sharing with us this morning?
Mr. Chairman, absolutely. Like I said earlier, a lot of times we have been abiding by under FAA regulations and rules to comply, to register aircraft, to get the proper licensing, to fly them on commercial purposes. We respect the neighbors. We tell people that we're flying in the area. We let them know what we're doing. Unfortunately, it's the hobbyists that buy cheap drones, as was mentioned earlier, and fly them into neighbors' properties and don't really understand what it is they're doing that causes a majority of the complaints that I've ever heard.
Thank you for that. Any questions for Mr. Richard? Really appreciate you being here. Thank you, Scott.
Thank you, Mr. Chairman. Thank you, committee.
Okay, Judy, we have someone else this morning?
There's no one else that has their hand up.
Okay. Okay, I'm going to close testimony on Senate File 34, committee. What's your pleasure on this bill?
Read the bill.
Moved by Senator Schuler. Discussion. Senator Cooper, you sat through the interim and then some good testimony here during session.
Thank you, Mr. Chairman. The bulk of the research I did reflected the testimony of Ms. King. There's Supreme Court rulings clear back to 1946 regarding airspace, and it addresses the substantial portion of it. I think that language has to remain in the bill. The courts and tort law says that that space in between there, between 500 feet or as the FFA has said, 400 feet in more recent law. The courts say that that's up to a jury to decide on a case-to-case basis, and I think that's what the law, what the bill says now. So if we move the bill forward as it stands, I think that's more than adequate. If we add this potential amendment, I don't think it weakens the bill. So I'm kind of neutral on the amendment. I think the bill is well written as it is because of the way the laws read. So I don't want to mess with the bill itself very much because we got it right. Do we need to add a little bit? Possibly. That would be my thoughts on it.
Appreciate it, Senator. I've certainly learned a lot and become convinced that this is an area of law that we do need to get into the green books with. I suspect, looking at some of the testimony we received, I think we're going to be working on this area of law for quite some time to come. It's developing all the time, but well, let's if there's no other discussion, let's work the bill, committee. We have a suggested or requested amendment that's been provided to us on page 2. What are the feelings on that one, committee?
I would move the amendment.
Senator Case and Senator Schuler, by golly. We are referencing the proposed amendment provided to us this morning by State Farm. It's also been reviewed, I think, by the Farm Bureau and by the rural electric cooperatives, among others. So, Senator Case.
Mr. Chairman, I don't know all the drone rules, but it says, I kind of want to tweak this just slightly. It says, and operating the small unmanned aircraft in a manner consistent with applicable FAA rules. I'd be more comfortable if we put part 107 of FAA rules.
Mr. Evans, would you be willing to come up to the front here so that we can lean on you for a minute? I like where sorry to interrupt, Senator.
No, that's all right. I mean, if the FAA's got a lot of rules about different things, and I'm not sure, seems like if we want to be very specific about these commercial operators, they come under Part 107.
Yes, they can also come under Section 333. Some of the original drones that were approved under that, and then they have broader organizations. So like something like Amazon doing delivery is not under Part 107. These are for individual operators, as well as the public aircraft operators that I also spoke to are not under Part 107. I unfortunately don't know the part under CFR that they are. And then if I may, also just to another point, I don't know enough about statute language, but where it says a business entity, I just want to make sure that government, local government and state government and federal government operations fall under the auspices of a business entity. They may under statute work for those purposes, but a language that's more appropriate to to fully incorporate anyone who might be operating, not just a commercial business, might be appropriate.
So, Mr. Chairman,
Senator.
we could eliminate the word business, but I would feel more comfortable if it had the specifics of the, to pilots that means something. 107 is for hire, but Amazon's operation is wholly owned, so it's not for hire. That's your point, right?
Yeah, and I'm not sure. I know that they are not operating under Part 107. They are operating under a special rule, and I don't know exactly what portion of federal law and FAA regulation they are operating under specifically.
And then, Mr. Chairman, there was one more category you said.
Public aircraft operations.
Okay.
And that's what allows fire district sheriff's offices, they self-certify their own pilots after getting their program approved by the FAA. They write a proposal saying this is how we would like to use UAS, and we'd like to have these exceptions to, FAA law, or we'd like to comply in this way. They get an approval, and then they run their own programs and train their own pilots and inspect their own drones.
And then, Mr. Chairman,
Go ahead, Senator.
I know that this is kind of tedious, but I think we need to specify the requirements for these commercial operators, because I think there's FAA regulations for everybody. I mean, theoretically, you can't fly a kite, and you don't need a license for that. But there's an FAA regulation that says you can't fly a kite at an airport. And so I'm saying everybody's under some kind of FAA. I still, when I do FFA, I had to pay for that steer. But anyway, so if we're going to try to get to these commercial or public use, I think it'd be better if we had the specific language. But we could pass the bill and leave it open. And I'm even willing to bring a second for a committee of the whole amendment if you want.
Senator Case, that's where I was going to go. As I read I'm reading this as you have visited with us. I think operating in a manner consistent with applicable FAA rules. That's a pretty good umbrella. And we can certainly fall in underneath, with a subparagraph to say, those rules include, being certified under 107 and commercial aircraft operated under 108 and, whatever. Does that make sense, Senator?
There's a needle that's stuck in there. So if a guy comes and buzzes my house, checks out the hot tub, and then, it's nosy Sam. He's trying to annoy me, but he is following FAA regulations in the sense that he's operating at safety and he's not safely, and he's not in a flight path, even though he's not a licensed operator. So there's that little wedge that a smart lawyer, and they're getting smarter, could open that up.
Senator Schuler, Billy, just a minute. Mr. Winnie, come on forward. You bet.
He can't hear this.
Quick comment, you've kind of touched on it here, but a private operator, a business, whatever, can also propose a specific operation that might deviate a bit from Part 107. The FAA can approve it and say, yep, within these limits, you can do X, Y, Z. And so your proposed amendment you mentioned just a minute ago would fit that and give you the umbrella you're looking for.
Senator Schuler.
Thank you, Mr. Chairman. I was just thinking of a way to broaden the amendment just a little bit by taking out the word business and just putting an entity doing business lawfully. I don't know if that helps the amendment or makes it too broad.
You know, Senator, I went to the same place and thought we could, business or government entity too, so we can certainly work that piece. I share the interest that Senator Case has on the FAA rules language on line 3 of the amendment. We may have to work that a little bit, Senator, and get with appropriate folks so that we can be a little more specific. In the meantime, if we were just stuck with this language, I think it's worth considering.
Mr. Chairman.
And we are on the amendment, so go ahead, Senator.
One problem with that is just because it's airspace doesn't mean it's still not trespass. There's a lot of reasons for businesses to come on my land, but they still ask permission. They don't just come in even because they're a lawful business operating in Wyoming. There's a lot of reasons for them to be there or not be there. And I understand some of the issues here, but trespass is trespass. And we're trying to carve out things for a lot of separate people, and I understand why. But that doesn't change the fact that they're still entering your property without permission. So we need to be careful what we do there when we just say a business lawfully in the state. I can think of a lot of them that I don't want on my place. So, thank you.
Yeah, good caution. Committee, I'm inclined to consider any amendments to the amendment. So let's consider that. Senator Schuler, you specifically went to line 1. This section does not apply to a business, and I believe one of our folks testified that we don't want to leave out government business.
Yeah. Mr. Chairman,
Senator,
here's where it gets kind of sticky, because you can say, well, according to Mr. Evans, a lot of this isn't business, it's government's working it. So you say, well, we can't have business. Then if we take out business, then we have an entity and maybe operating lawfully in the state using small unmanned aircraft for legitimate purposes. Then the whole thing is on top of legitimate. Then it's not much different than the paragraph up above.
so Senator Schuler, your thought was to just simply take out the word business. Is that a
Apply to
motion?
an entity, which just to broaden it a little bit.
Is that a motion?
I'll make that motion.
Okay, Senator Schuler has moved that we strike the word business in that first line. Does everybody understand what we're voting on? Amendment to the amendment? Senator Case, are we good?
Sure, I can support that, but we rely on the word business elsewhere in the paragraph. And maybe it's kind of a generic thing, government has business, I have business, go do your business. It's got a generic connotation to it that I think means purposeful, but we're relying a lot on those business purposes and doing business lawfully. But I'll support the amendment. I think we're going to be working this later, but that's okay.
Yeah.
Mr. Chairman?
Go ahead, Senator Cooper.
On the ag side, if a gentleman is, a rancher is missing some cattle, and he wants his flies drone around to look for them, he's going to fly over the neighbor. That's a business. But maybe him and his neighbor don't get along very well. That's still trespass.
Senator
Mr.
Schuler.
Chairman, I'm wondering though, again, good question, if I think what makes it more specific is legitimate business purposes. I think that's maybe what protects the one rancher from doing business, but I don't know. Legitimate and lawfully.
Committee, I'm inclined to, I think we go to the question on the amendment to the amendment, striking the word business, striking a business and replacing it with the an entity. Does everybody understand? All in
Question.
favor of Senator Schuler's motion, please say aye.
Aye.
Any opposed, no.
No.
Okay, that amendment to the amendment passes. We are on to line 3 was another area that we have spent some time on. I'm not sure we can quite get there today without some homework. Mr. Evans didn't have specific references and there's significant 3-part rules, et cetera, in the FAA. So we may have to go upstairs with what we've got if we end up passing this amendment. So anything else on the amendment? And Senator Cooper's offered some good cautions. The whole purpose of the bill is the fact that we're dealing with trespass. So Senator Cooper, go ahead.
I think we need to, as far as the entire amendment, we probably need to get some really good legal advice on it from LSO and do a little more research on the amendment. I think that the amendment, there's probably a place for it. But we've got to be careful that we don't weaken the bill. And as it is, I'm afraid we may, after we read it and really think about it, I'm afraid it may actually weaken the bill a little bit. And we don't want to go there. I have no doubt that on the floor, we're going to have, it's not going to be a 5-minute discussion. So I would like to see us kind of table the amendment for now, and we can bring it back as a committee of the whole amendment after we've done some really good research on it and get some really good advice on it, on how to best word it. So that would be my recommendation.
I think there's some wisdom in that, committee. I think we're going to table this. Let's take it upstairs. I think Senator Case made a great point that we can look into the FAA part of things. We can make sure that we're inclusive. We've worked it a little bit today to get it in position to take to our legal staff upstairs, and I think we can come on committee of the whole, even and work it on into the second reading, as long as we let the body know. Senator Case, what
Mr. Chairman,
say you on that?
I'm a little disinclined to table it. I think it's a step in the right direction, but I'd like to go with it later. But this is a good committee. We'll get each other's back, and we can do it either way.
Okay.
Mr. Chairman.
Go ahead, Senator Cooper.
I would like to thank the bringers of the amendment. I think they did some good homework, and it's prompted a lot of good thought here and good discussion.
Yeah.
So I would like to recognize them for doing that.
Yeah, thank you for that, Senator. I think we'll table this and take it upstairs, committee, the amendment, and that takes us back to the bill. Is there anything further on Senate File 34? Are you ready for the question on 34? Judy, please take roll on Senate File 34.
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye. And
Mr. Chairman, there were 5 ayes on Senate File 34.
and I would invite committee, anyone who would like to join me in taking this to our legal staff to see if we can't get some help on that. I'm reading that the committee has an interest in including this amendment. We can all support it. We can all sponsor it if we want to upstairs. So, okay. So Senate File 34 has passed the committee. The next bill for our consideration is Senate File 54, Judges Housing Allowance. Okay, Lisa. Yeah. Was it something that we said, everyone? Thank you, everyone. Appreciate it.
when we start bringing Alyssa forward, things go down.
Yeah.
Thank you.
Ms. Butler, would you like to come down front and catch us up on what we're doing on the judge's housing allowance? Senate File 54.
Mr. Chairman, members of the committee, my name is Elisa Butler, and I am the State Court Administrator for the Wyoming Judicial Branch. So this bill that you have in front of you today, Senate File 54, really is designed to bring judges within the policy that's applied to other state employees throughout the state. So currently, state employees receive a housing allowance if they are deemed eligible. So every year, A&I does an analysis to determine where the cost of housing is substantially higher than the rest of the state. And then based on that analysis, they provide a housing allowance to state employees who are eligible, where the housing costs are substantially above those for other employees statewide. Currently, the only county that is eligible for that housing allowance is Teton County. But that policy applies to every county in the state. So if another county, for some reason, Lincoln County comes to mind with the boom that's happening there, if the housing costs go up substantially there, those employees may be eligible based on the analysis done by A&I. Judges currently are exempt from that housing allowance because they receive salary as part of a statute. So they are only permitted to receive the salary that's set forth in statute and cannot receive that housing allowance. Other judicial branch employees that currently live in Teton County do receive that housing allowance. So we have circuit court clerks there who receive that housing allowance, and then the chamber staff or the district court judge in Teton County receive that housing allowance. So really what this bill does is it just provides for a mechanism for judges to be brought within the policy for the rest of state employees to receive the housing allowance if they're deemed eligible based on the analysis done by A&I every year. So, Mr. Chairman, that really is the purpose of the bill. That's what it does, and I'd be happy to stand for any questions.
Ms. Butler, I lost you when you indicated, I thought you indicated that some judges do get some help. Can you go back over that? Did you? I probably misheard that. So up in Teton County, none of our judges get any help.
Mr. Chairman, that's correct. So their chamber staff receive the housing allowance. So they have, so they have a court reporter, a law clerk, and a judicial assistant at the district court level. All of those employees, if they live in Teton County, receive that housing allowance. The same is true for the circuit court. So the circuit court clerks all receive that housing allowance if they reside in Teton County currently.
I don't know if you realize we had about a 2-hour visit in the Senate chamber yesterday about this sort of thing going on the Western Front. So we're familiar with it, right? Senator Cooper, did you have something for Ms. Butler?
Thank you, Mr. Chairman. Ms. Butler, would you say that this bill as it's written simply brings the judges into the same category as the rest of the state employees? Is that the purpose?
Mr. Chairman, Senator Cooper, yes, correct. That's what I would say.
Senator Case.
Thank you, Mr. Chairman. Ms. Butler, welcome. Thank you. Do you know, do judges typically own their houses, or do they rent houses? Do we know?
Mr. Chairman, Senator Case, this would be purely a guess, but my guess would be that most judges own their houses. The judges that we have in Teton County right now, so we have Judge Owens at the district court level and Judge Rada at the circuit court level. Both of those judges have resided in Teton County for many years.
So, Mr. Chairman, Ms. Butler, I think that's typical that when a judge is appointed, lots of times you look at the pool of people that already are there. And so the point I would make with perhaps and ask a question, if you already own your home and you're appointed to be a judge, and then your home's appreciating with everybody else's homes on the state, you've been there a long time, you've been able to afford that home, you willingly sought to be a judge. I'm not sure it's a good idea for the state to give you $1,900 a month when you already own your home. and you wouldn't have sold it anyway because it's the best deal in the country because real estate's going like crazy. And so that's where I'm hung up. Court staff, they may choose to go to Teton County, but they work for the state and they kind of go where we need them. Judges can decline an appointment or seek an appointment in particular areas. I hope I'm making some sense.
Yeah, I think good points made, Senator. Ms. Butler, any thoughts on that front?
Mr. Chairman, I do, and Senator Case, I do, it is a good point, but I do have just one, I guess, point to make to that. And that is, not too long ago, Judge Owens has, I cannot remember her appointment date, but that position for the district court judge in Teton County came open not all that long ago. And so when there are vacancies in locations where the housing costs are high, it really does limit the pool of applicants for those judgeships. So because Teton County is the one that we think of most readily, but again, this could happen in any county if the housing costs go up substantially. But those judges or those attorneys who apply for those positions generally reside within that location. And so it really does limit the pool of judges that we have to choose from if the housing costs are too high in a certain location. And I think just what we would like to see, obviously, is to have a very robust pool for every judgeship we have across the state, and not just limit those to the communities in which those attorneys reside. So I think one of the benefits of a housing allowance like this is it does allow for people who don't necessarily live in a high-cost community to apply for those judgeships and be able to live in those locations or move to those locations. We do have, it does happen pretty frequently where we'll have in other locations applicants that apply that do not live in that community and then come in from different communities. But in Teton County, it is very limited just because of the cost of living and the cost to move to that location.
Senator Case.
Well, Mr. Chairman, couldn't we limit this to new judges moving to a county and time limiting? Give them 12 months of housing allowance if they move to a new location.
I think that's within the realm of what our committee could do, Senator. But Ms. Butler, any comments on that?
Mr. Chairman, I think we would be opposed to something like that. And again, it would just be based on, the length of time. I mean, if you're buying a home in a place like Teton County, 12 months of a housing allowance is not going to help you with your mortgage for the next 30 years. And I don't know that a year of, what would it be, about, so $2,000 a month, so $24,000. I don't know that would be enough of an incentive for somebody in a lower cost of living location to move to a place with substantially higher housing costs.
Mr. Chairman.
Go ahead.
I'm sorry, just the final point of that,
then
though.
we'll go to Senator Furphy.
And I apologize. The judge owns the house when it's all done. He can borrow on the house. She can borrow on the house. He or she gets to sell it and gets to reap the benefits of the appreciation of the houses are happening. That's the upside. They want to pay us back the housing allowance, I'd be fine with that.
Senator Furphy.
Thank you, Mr. Chairman. Let me ask about this weighted average cost of housing. If you can help me understand that, who calculates that? And how often does it change? So that means we would have to compensate the judges whenever this weighted average cost changes. If you could help me with that, thank you.
Ms. Butler.
Mr. Chairman, Senator Furphy, the way that it works right now for other state employees is ANI does an analysis every year. So it happens annually. So they look at that every year to determine, what the housing costs are across the state, if other counties have gone up or down, and whether or not state employees in counties other than Teton right now are eligible for that housing allowance. So I think the last study was done, I believe, in July, although I could be wrong about that. And it did go up for Teton County. So it was at, I believe, $1,600. And then it moved up to $1,900. I believe it was this past summer.
Senator Schuler.
Thank you, Mr. Chairman. Just a quick question, and I don't know the answer to this, obviously, but are judges required to live in the county where they are judges?
Ms. Butler.
Mr. Chairman, Senator Schuler, so that is statutory for district courts, and it varies. And so within Title V, I'll give you an example. So district courts are much more specific than circuit courts. In some places, they are required to reside in the judicial district. So the 6th judicial district comes to mind, and that covers Campbell County, Crook County, and Weston County. There are 3 district court judges there, and they cover all 3 counties. All 3, well, I think 2 out of the 3 district court judges reside in Campbell County. One of them resides in Crook County. And so they basically write a circuit. In other courts, it is very specific that the judge has to reside in the county. The 4th judicial district comes to mind. So Sheridan and Johnson counties, we have 2 judges there, one in Sheridan County, one in Johnson County. And I believe the statutes require that they reside in each of those counties.
So, Ms. Butler, I happen to know that we don't have that requirement on teachers, sheriff's deputies, plow drivers. A lot of them, frankly, live over in a state to the west of us. But I think what I heard you say is that the judges have to live in Teton County.
Mr. Chairman, I'd have to go back and look at that specific section of the statute, but I believe that's correct.
Any other questions for Ms. Butler? Yeah, thank you for being here on this one. Appreciate it.
Thank you, Mr. Chair.
Would anyone like to provide testimony on this bill? Is there anyone online, Judy, waiting to
No,
do
Mr.
so?
Chairman, there's no one online.
Okay, we will close testimony. Committee, what's your pleasure on this bill?
Move the bill.
Senator Cooper moved the bill. Discussion. Senator Case.
Proposed amendment? My proposed amendment would be, Mr. Chairman, I would move that we, on line 15, after the word assistance, we insert for 12 months. And then if the judge or justice strike the word resides and put moves to, we also have to strike the word in a county. So may receive housing assistance for 12 months if the judge or justice moves to a county in Wyoming where the average cost on.
Hey, does everyone understand that proposed amendment? Judy, do you have that? Do you need the senator to provide that again? Okay, for 12 months if the justice moves to. Okay, discussion? Does everybody understand the amendment? Question on the amendment? All in favor of Senator Case's amendment, please say aye.
Aye.
Any opposed, no? That amendment has passed.
Question on the bill?
We are back on the bill. Question having been called. Judy, please call the roll on this bill.
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on this amended bill.
And Senator Sewer did a good job according to the language up there. SEWER.
I've been called worse.
Boy, haven't we all?
I'm so sorry.
Referee.
I'm just making sure that's crazy.
Senator Furphy, do you want to take this upstairs? You want to take this one out on the floor? We're right behind you if a fight breaks out. All right, good deal. We are going to have to re-refer this one, Senator, so it'll be off and about for a while. Okay, third bill for our consideration this morning, committee, is Senate File 91, creation of tenancy by entirety. And I don't see the senator here.
I thought we could do this.
I think we can.
I'm thinking that we can. We touched on this a little bit last night, you'll remember. So,
And maybe Ms. Butler would like to come up and present it for.
Marion, you, nope. Never practiced law outside your area. Got it.
okay, at the bottom, 34-1-140, establishing joint tenancy or tenancy by entirety in real and personal property. And we add paragraph B, designation of tenants on an instrument of conveyance or transfer of real property as husband and wife, spouses, or similar language shall be sufficient to establish a tenancy by entirety under subsection A of this section.
Yeah, and Mr. Chairman,
Go ahead, Senator Case.
I think this is good, and this is the obvious. If, you know, if you and your wife did not want the property to be held in tenancy in entirety, you would do something different. You would own it as individuals, you didn't have a prenuptial or however you need to get that. So, but if you purchase something and you're representing, and you sign it as spouses or husband and wife, what other way could it be? And that would, and you do see that once in a while, signing as husband and wife.
You know, it's a little bit surprising to me, committee, that that this is not in our statutes already.
It's probably the state of the law, but it's not in the statute.
I bet it's in case law, not senator case law. I'm talking about the other case law, lower case law.
Same thing.
Yeah, there you go. Is everybody comfortable with what the bill kind of does? I'm not well versed in tenancy and et cetera, but I think we know what the committee, what the bill does. So, anything else, committee?
Judy says there's nobody online and nobody wants to testify here. So if I move the bill, is that okay?
I think so. And we're gonna close testimony. There's nobody here to testify, and that's fine. We've got pretty good trust in the prime sponsor of the bill to go upstairs with it. And so, question on the bill? Judy, would you please call roll on Senate File 91?
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on Senate File 91.
Thank you. Senate File 91 has passed the committee, and that gets through our bills for this morning. Committee, just for information purposes, we have, about 7 or 8 bills that are still in the hopper. I'm not feeling quite as much urgency as I did in the early part of the week, so thanks for all your hard work to catch up a little bit. I'm inclined to get in early on Friday, just so we can maybe get another 3 or 4 bills done and get them upstairs, but we do not need to meet on Thursday afternoon or anything like that. I think we'll just meet on Friday morning, and if everybody's good to get up before breakfast, we'll get right after it on Friday again. So.
Did you say you're bringing breakfast?
Yeah.
You should.
That's what I understood.
Yeah. Well, I tell you what,
That's only fair.
Pretty tough crew.
yeah, I tell you, it's tough. I much appreciated, everyone. We are adjourned.